Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Thursday, January 8th. Today, we're going to update on several cases we've been following, including Nick Reiner, Spencer and Monique Tepe, Ashlee Buzzard, and JP Miller. If you're watching on YouTube, don't forget to hit subscribe. Liking the video is one of the best ways you can help this podcast. And if you want notifications of when I post new content, just click that little bell icon. So let's jump in. We're going to start off with Nick Reiner. Yesterday, Alan Jackson, Nick Reiner's attorney, withdrew from the case at what was supposed to be Nick's arraignment. The official reason wasn't given, but a lot of legal analysts believe it could be money related, especially since Nick has since been appointed a public defender. Some of the other reasons legal analysts have mentioned are fundamental disagreements on how to defend the case or a conflict of interest. Jackson said he was withdrawing with Nick's understanding and consent. While in court, Nick spoke calmly with his defense team before all sides went into the judge's chambers. Mark Bedrow told the New York Post about Jackson withdrawing. It's clear Jackson didn't want to. And I can't imagine that the client wouldn't want a lawyer of Alan's skill set and capability to go. I'm purely speculating, informed speculation. A representation like this could cost an extraordinary sum of money. Probably the money is not there. Some legal analysts have estimated that a case of this caliber could require a retainer that is 7 figures. Jackson said he and his team remain deeply committed to Nick Reiner and to his best interests. He said, in fact, we know, we're not just convinced. We know that the legal process will reveal the true facts of the circumstances surrounding this case, Nick's case. He said after spending literally every waking hour investigating the case top to bottom, he said, Nick Reiner is not guilty of murder. Print that. Meanwhile, LA County District Attorney Nathan Hochman, in his own statement to the media, said, we are fully confident that a jury will convict Nick Reiner beyond a reasonable doubt of the brutal murder of his parents. Now, we know Nick faces life in prison or the death penalty for killing his parents. DA Nathan Hochman has not made a decision, but it's largely believed by the legal community that the DA won't go for death. By the way, there hasn't been an execution in California in almost 20 years, and Governor Newsom stopped executions altogether back in 2019. That will remain in effect until next year, which is the end of his term. Speaking of the death penalty, friends and family have told outlets they don't think the Reiner family would want that because Rob and Michelle were very much against the death penalty. And it's widely believed that Nick will use the insanity defense. I'm sure he's already had several mental health evaluations. But if he's deemed to be incompetent, that could put the brakes on this case indefinitely until he's restored to competency or if he's not. But due to the fact that Jackson withdrew, the arraignment was postponed to February 23rd. When asked if he agreed to that, Nick said, yeah, I agree to that. After the hearing, Nick's family gave a statement to E! News saying they have the utmost trust in the legal process and will not comment further on matters related to the legal proceedings. Moving on to Spencer and Monique Tepe. Still no news regarding the investigation, but a few things have come out. Number one, for rumor control. There was a 911 call that was placed from the home in the middle of the night on April 15th last year. A woman was heard crying, saying she had gotten into it with her man. She said she was okay and didn't need help. Family is saying that is not Monique on the call. Monique's brother-in-law, Rob, said it wasn't her and it doesn't sound like anyone else they knew. He said, whatever Fox News showed, I think it just maybe pinged at their address and is probably a neighbor. It's so obviously not Monique's voice. It's not them. It was initially reported that this was during a party, but the brother-in-law clarified he got the dates wrong and it was not during a party. So moving on, a woman who lived on the same street, only about a 3-minute walk from the Tepe house, said she called 911 on December 19th at 2:31 a.m., saying that someone was banging and knocking on her door. I think the reason this has kind of made the news is because the killings are estimated to have happened between 2 and 5 a.m. Eventually, the person just left. But my gut still says this is somebody they knew. Having no signs of forced entry is so big to me. And also, they're not really putting out there that there is a threat to the community, which to me speaks volumes. I mean, my opinion is maybe they just have their sights set on a suspect, but definitely don't want to put that out to the public just yet. As far as the video of the person of interest that was released, CNN asked why they're interested in this person and why they're not considering them a suspect. Columbus Police Sergeant Joe Albert said, in order to maintain the integrity of the investigation, we cannot answer that question right now. But police did post on Facebook, we want to thank the community for the tips we've received. We know there's questions and concerns surrounding this tragic incident. Detectives are working diligently to solve this case. We will continue to update you as the investigation progresses. So that's the latest on that one. And moving on to Ashlee Buzzard. She is accused of shooting her daughter Melody on a road trip in Utah. She was in court yesterday with a packed house to set the date for a preliminary hearing, but she waived the 60-day right to a preliminary hearing and extended a specific waiver through March, so the earliest it would happen is April, if then. The hearing lasted less than 5 minutes, and Ashlee only spoke when she answered yes to the judge. Melody's paternal grandmother, Lily, spoke after the hearing and said, "When I met her 9 or 10 years ago, she wasn't like this. I don't know what happened. When my son brought her to the house, she was really quiet and just looking at me from head to toe. I told my son, 'Mijo, is this girl okay?' She's just staring." She said her son replied, "Mom," because she's shy. Lily said she did not see Ashlee much, but they did throw her a huge baby shower when she was pregnant with Melody. She said, "All my family came. That can tell you how much we loved her," meaning Melody. "We loved our baby very much. I don't know what's going through her mind that she did what she did, but she could have given us the baby." She also thinks Ashlee will plead insanity, but she also said, "I don't think that's right because she planned everything. You know, the license plates and moving them and all this." And here's the thing. You can be mentally ill, but you can also be culpable at the same time. When you take deliberate steps to cover up your tracks, it means you know what you did was wrong, and you'd likely get arrested if you got caught. Lily said she's also been in contact with Ashlee's mother. Ashlee's mom sent Lily a message that said, "God help us." And I said, yes. Lily said, "So I'm sure she's hurting the same as I am, but she's hurting for her daughter. I'm hurting for my grandbaby." The defense is asking for a permanent gag order to be issued prohibiting law enforcement from talking about the case publicly or giving any details of their investigation. They want to do this to prevent tainting a future jury pool. This motion and also a motion from the defense regarding details from the warrants in the case will be heard January 21st. Erica Sutherland appeared for the defense yesterday and said she was planning to file a Hobbs motion related to sealed warrants. She said, "We want to unseal the search warrant because we want to find out who the confidential informant is. Who's the one they're relying on for the probable cause?" That's the Hobbs motion. So what is a Hobbs motion? It would mean that certain parts of warrants would be withheld to protect the safety of informants and or protect the integrity of the investigation. Her attorney told KSBY, "Cases like this, the judge will want to see a preliminary hearing within 6 to 8 months, no more than a year, and it takes a while to pull all the evidence together to be able to put on that preliminary hearing." So with that, I really don't expect many major movements in this case for a while. Maybe some court dates for motions and things like that, but sounds like it's going to be quite a while before we get to that preliminary. Last up, J.P. Miller. He dropped his appeal against a former church member, Sam Rickman. J.P. sued Rickman last January for invasion of privacy, harassment, screaming at him, and making defamatory posts about J.P. on social media. Rickman filed a counterclaim and was awarded $3,400, which is what JP was appealing. And speaking of filing lawsuits, in January of last year alone, JP filed almost 20 lawsuits asking the maximum amount of $7,500, which is the max that's allowed in magistrate court. All of those were dismissed. His arraignment in federal court is next week on January 12th. He faces 5 years for the cyberstalking charge, and lying to investigators is up to 2 years. The allegations span 17 months and includes sending Micah unwanted and harassing communications, posting a nude photo of her online without her consent, installing tracking devices on her car. He contacted her more than 50 times in a single day. He interfered with her finances and daily activities and damaged her tires. When asked about these allegations by federal investigators, he lied, hence the lying to investigators charge. When the indictment was announced, U.S. District Attorney Brian Sterling said marriage should be a place of peace and support, and it turned into a nightmare for Micah. The U.S. attorney on this case is asking for discovery, including all prior statements in possession of the defendant, if any, given by witnesses who the defense expects to call at trial, other than the defendant himself. All books, papers, documents, photographs, tangible objects, or copies or portions thereof, which are in possession, custody, or control of the defendant, and which the defendant intends to introduce as evidence in chief at trial. Any results or reports of physical or mental examinations and scientific tests or experiments made in connection with this particular case, as well as the names and or opinions of any such experts conducting tests, experiments, or examinations within the possession or control of the defendant, which the defendant intends to introduce as evidence in chief at trial or were prepared by a witness who the defendant intends to call at trial when the results relate to their testimony. They're also asking for a written summary of testimony the defendant intends to use under Federal Rules of Evidence 702, 703, and 705. So what do these rules mean? Rule 702 revolves around expert testimony and just making sure that they are indeed an expert in the field. Rule 703 is an expert may base an opinion on facts or data they personally observed or facts or data made known to them through reports, interviews, tests, or records. Rule 705 controls how and when that basis is explained. The defense asked for grand jury transcripts, forensic and scientific test results, all materials that could be favorable to the defendant, including evidence that could negate criminal intent or impeach the credibility of government witnesses. They also want disclosure of information related to the tracking devices, car surveillance, and digital monitoring. The next day, federal prosecutors asked for reciprocal discovery, asking JP to disclose all evidence he expects to use at trial, including documents, photographs, physical evidence, expert reports, and prior statements from witnesses the defense may call. They're also asking for early disclosure of defense witness statements under federal discovery rules, citing fairness and efficiency in trial preparation. While the indictment doesn't accuse JP of being responsible for Micah's death, it's important to note the end date of the conduct was April 27th, 2024, which is the day Micah died. This case is going to focus heavily on electronics, digital timelines, and surveillance records. Now, if you're planning on attending the arraignment, which is set for 2:30 on January 12th, there are a lot of rules you need to be aware of. It says members of the public are prohibited from bringing cell phones, smartwatches, fitness trackers, laptops, tablets, cameras, video or audio recording devices, newspapers, ebooks, liquids, gels, aerosols, lighters, matches, or any electronic devices. One exception is you can bring a container of hand sanitizer or lotion, but no more than 3.4 ounces. That hearing should not take long at all, which is exactly why I'm not driving down. That is going to be at the U.S. Courthouse in Florence, South Carolina. The attorney for Micah Miller said the level of abuse Micah suffered at the hands of JP was jaw-dropping, and she said she would not be surprised at some point if there are more charges filed. So that is it for today. I'll keep an eye on everything. If anything new pops up that's quick, I'll probably do a YouTube short. So again, make sure you're subscribed and click that bell notification to let you know when I post something new. Hope you guys have a good rest of your day, and we will see you soon.